Today I went to the Eli Lilly Vs Mochi hearing in person in San Francisco. I went to their previous hearing in August, and I feel very complicated about it. I normally do short form video. I'm going to try to do this all in one long form video because, to be honest, like I need more time to talk about the details, but I do not have the time to do a ton of editing. So please be patient with me. I would say opening things up, the judge sounded like she felt like Eli Lilly had standing. And previously, I think in the previous hearing, it felt like a slam dunk for Mochi. It was like, I'm going to dismiss this. Where are the facts? Like, you're asking too much of it. She literally told Eli Lilly it wasn't their best work. And this time she actually said, good job. Yeah. So if you don't know who I am, I'm Sabina. I do a lot of short form content. I want to do more long form content on YouTube. I work in the industry. I made a tool called GLP Winner that helps people compare providers. And a lot of my content has to do with access because we're all anxious about our access going away. We all care about how much things cost. And as a result of that, I end up kind of doing the news. I go to litigation hearings. I've gone to Washington, D.C. to do Hill visits. I follow some of the legislation, and I need to be on YouTube and doing longer form videos. So here I am. Thanks. So first of all, I want to say the judge sentiment was just kind of that it was going to move forward. And I spoke to someone who worked for Mochi afterwards, and they basically said they were expecting it. They were expecting it to be harsher. The stakes are sort of that if the judge dismisses this, because this was about a dismissal, if the judge actually dismisses the case, then that's kind of it. There's a bunch of other cases against Willow, against telehealth, against Henry Meds. Some of them have been fully dismissed. Some of them have been partially dismissed. Some of them haven't been dismissed at all. And I think I will say to the judge's credit, she is clearly very smart. She's very, very engaged, and she's very expressive. So it's very obvious what she's thinking. I would say, the vibes overall were very, very mixed. It was not a slam dunk. So let's get into kind of what we were talking about line by line. So one of the first things is, was there Article 3 standing? Meaning, like, can this litigation go forward? And for that, it sort of hinged on two claims from Eli Lilly. First was that there was reputational harm, meaning that they're alleging that the compounded version of tirzepatide is inferior to the compounded version, is inferior to the FDA-approved neighbor version like Zepbound or Mounjaro. And with reputational harm, it's sort of this claim that if a patient goes and gets compounded medication from Mochi and they have a bad experience, that's actually going to prevent Eli Lilly from getting customers. And then the second claim is on lost sales, meaning that Mochi is diverting or taking customers from Eli Lilly. And at points, I'm not sure if it's this case or other cases, there have been claims that literally they prescribe 0 prescriptions for Zepbound, which I don't think is actually true for Mochi, but that's some of the claims we've been seeing. So the judge literally said, okay, let's start with reputational harm. And by the way, I have 14 pages of notes. And they sort of talked about, like, it needs to be more linked to Mochi than just in general, because a lot of, let me go to reputational harm. Okay, it needs to be linked to Mochi more than just in general. A lot of what was being brought up was sort of just like Eli Lilly casting dispersions on compounding in general and saying that compounding in general is harmful to Eli Lilly. But, like, how was Mochi specifically harmful to Eli Lilly? That was kind of the argument. And, there's a lot of conversation about confusing advertising and, is it reasonable versus is it plausible? Are there enough facts? What's interesting is the judge brought up, like, why did the FDA make warning letters to providers? I'm pretty sure Mochi didn't get one. I would have to check. I will check after and mention it in the comments. But basically being like, why were there warning letters sent to compounders if there wasn't reputational harm or there wasn't something confusing? What I wish had been brought up that wasn't brought up by Mochi's defense was that, let me just say my opinion. Okay, what I wish had been brought up that wasn't actually brought up was that the FDA does have reporting for adverse events for compounded. And while it's likely compounded is somewhat underreported, they basically said that they weren't significantly different than name brand. So I kind of wish Mochi's counsel had brought that up. I'm kind of surprised they didn't. But they were looking for factual information to show reputational harm for it. Was it confusing? Another interesting thing is they kept bringing up Reddit posts. I'm going to talk about Reddit posts in general as kind of a theme. Then we sort of go to lost sales, hinging on, were those patients going to go to buy Lilly's name brand drug anyway? Or were they, was Mochi materially reducing the amount of sales, or was Lilly's product actually more expensive? In the first hearing, the judge literally knew it was expensive, knew it was overpriced, and straight up said those patients probably wouldn't go and get name brand medication because they probably couldn't afford it, and it was about price. The judge was like very clued in on that. And now I think, Eli Lilly's lawyers, previously they couldn't confidently tell the price of the medication. They literally said, I think it's this, but I'm not confident in that. This time they had the number, and it was, I think it's the $299 number, which is the lowest dose only, which is not what most people on Lilly Direct are actually paying. So that was interesting. And the argument that Mochi brought on lost sales is that, again, it goes into, are they competing or not, which is like, Eli Lilly's a drug manufacturer. They only sell to distributors. So Eli Lilly sells medication to wholesale distributors that then distribute to retail pharmacies. So are they losing customers if the consumers and patients that Mochi is soliciting or getting are not actually Eli Lilly's customers? Eli Lilly's customers are not patients directly. It's more complicated than that. That was the argument. And at one point, the judge kind of said, like, why is Eli Lilly spending all this money filing these lawsuits if they don't perceive that they're losing customers? And I think, like, obviously Eli Lilly doesn't like compounding. Clearly, they think they're losing customers. They keep bringing up Mochi advertisements being like best weight loss treatment. And if you want the best weight loss treatment, you go with Mochi and you end up going to compounded. The argument is that that's diverting sales from Eli Lilly, because Eli Lilly spends a lot on advertising. I think the judge said that they spend like $10 million a month. And I'm sorry, that's like way too low. They spend way more than that. But anyway, so they were talking about like Mochi doesn't produce drugs, doesn't sell drugs. They're a telehealth. And so it's important to understand in the scope of this case, I'm saying Mochi, but it's actually three different parties who are being sued. It's Mochi, the telehealth company. It is a doctor group that is associated with Mochi. And it is Equita Compounding Pharmacy, which I think is no longer operating at all. And the argument from Eli Lilly is that Mochi owned all three of these and they were vertically integrated. Now, the devil's in the details. Mochi claims that they didn't own all three of them. And Mochi's also kind of claiming that they weren't. And practically, I think people have just like interesting corporate structures. But there's some close-knit relationship, it seems like. So then there's the argument of, well, is there standing for the compounding pharmacy then? Because the compounding pharmacy does manufacture drugs and Eli Lilly manufactures drugs. And it's sort of like, I feel like Mochi's lawyer kind of got walked into that argument and kind of like backed out of it like, I don't know, because they had different litigation lawyers there for all three different entities, which is super interesting. And it's interesting because there's the argument of like, is compounding competing with name brand medication or FDA approved medication? And one of the questions was around, is there substitutability? Meaning like, could you take either medication? And the judge, like Mochi claimed there wasn't substitutability. The judge said that they didn't necessarily agree with that. And sort of talked about how the shortage ended and Mochi has continued to create these medications. She sort of like, I mean, she knows, she said in the last hearing, like, there are no angels here. This is all about money. So she knows it's about money. She thinks that, they kept going after the shortage because they wanted to keep making money, and money makes them feel good, basically. And one of the claims is also that Mochi mass switched formulations after the shortage and made public social media posts basically saying that they were switching formulations, and that that's not actually customized. It's interesting because Mochi argued that they went from a compounding pharmacy drug to another compounding pharmacy drug. It wasn't like they took from name brand to name brand. These were not Eli Lilly's customers, and then they continue to not be Eli Lilly's customers. So was it actually lost sales? Interesting, right? They also talked about when Mochi mass switched compounding pharmacies near the shortage ending, added additives, switched dosing, did that in mass. Is that truly customized? Is that really like the doctors doing that? And the claim from Eli Lilly is that Mochi is giving their doctors protocols to doctors that they hire, and that Mochi more directly controls the doctors, which broadly is a big no-no because that would be corporate practice of medicine, which I'll get into later. So the judge basically said, like, we can't accept that no doctor would ever do anything wrong. We obviously know there are bad doctors out there who do unethical things. We can't just assume because a doctor decided something is appropriate that they were doing so for good reasons. Interestingly, like, that's super negative towards Mochi, and it's definitely a 180 from what it was previously. And basically, like, if we're talking about directing consumers to a compounding pharmacy, we need to show substitutionality. Like, if they weren't on the compounded version, they would definitely be on the Eli Lilly version. And even Eli Lilly, they claimed in a lawsuit, I think it's one of the compounding pharmacy lawsuits that I covered a year ago, that branded medication is not always a fit for patients. And then I think Mochi did something that might have been one of their big mistakes. So I'll talk about that. So I'm curious to think if this was a mistake or not. But they brought up this situation where basically it's not advised for somebody like Mochi, or like for compounding, you can't really do it on price, right? You can't say, I'm compounding this medication because it's the same medication, but it's actually cheaper. That's a legal no-no. However, Mochi brought up the situation where a patient, in having a conversation with their doctor or their prescriber, they can take into account price. And the compounding pharmacy itself can't take into account price to compound or not compound. They're just filling prescriptions that doctors have written for them. And it's at the doctor's discretion. And that in a private conversation that a patient has with their doctor, they can say, hey, do you want this medication? It's really expensive. Can you afford that? And the patient can say, like, not really. And then they can be like, well, there's this option that's actually cheaper. So is that allowed in those conversations? It kind of got a little bit off the rails a little bit talking about that. Because of course there's a precedent that compounding can't happen because of price. So it got a little muddled in there. And I kind of wondered if that Mochi's counsel felt like it was a mistake that they brought that up. And so eventually the judge said to Eli Lilly more directly, like, is there evidence that doctors are steering to compounding pharmacy? And they mentioned that this is the first time prices come up as like a reason to have an exception for compounding. And they kind of shied away, didn't want to get into it, kind of too messy. So what's interesting is Eli Lilly kept claiming that Mochi has an incentive to do compounded because they make money off of compounded. And of course, Mochi's like, no, we're a software company, we're a telehealth. As I said, all three parties are kind of sitting in the room. The judge brought up, like, they own this compounding pharmacy. You can't really say that they aren't making money off of it when they own the pharmacy that it's going to. And Eli Lilly basically claimed that they're taking patients that would otherwise be appropriate for name brand and then putting them on medication that Mochi gets a bigger cut of, and that's their incentive. And the judge basically said, which is very different than the last hearing, that she needs to infer kind of like the best possible scenario for the plaintiff, Eli Lilly. She needs to infer in that way Otherwise, she shouldn't grant the motion to dismiss. This was all about a motion to dismiss. And, I'll say the sentiment leaving is that she might not grant the motion to dismiss. She basically said at multiple points she thought they might have standing. And they were looking for, facts on substitutionality, like if they could substitute medication for the other. There was somewhat a lack of facts. And the judge, said that standing doesn't require that the products be perfectly identical, because with additives, they clearly aren't. They're two different treatments. Eli Lilly's counsel brought up this situation where they searched on Google for Zepbound, their FDA-approved name brand medication. And in the search results, a promoted search result showed up for Mochi Health. And they're like, they are diverting patients. It's really interesting. And let me just say my opinion on this. When you're buying ads on Google, like Google search results, you don't always get to, maybe you could if you set up the advertising just perfectly, but you can't really pick where your ads show up. Oftentimes, in its simplest form, Google is trying to put ads where it thinks people will find a result that they will click in through. So it's possible that Mochi intentionally targeted search terms like Zepbound, but it's also plausible that that could happen when they did not do that. Unless they specifically told Google, do not search for Zepbound, the algorithm is going to try to make that connection anyway. So I thought that was very interesting. Okay. Now we get into corporate practice of medicine. Now, if you don't know what the corporate practice of medicine is, at the very, very simple high level, it's any outside influence that's influencing how doctors are prescribing, right? So if I started a company and hired a doctor and said, you must prescribe in this way, or else you're going to lose your job, or I'm telling you how to practice medicine, that's a big no-no. We want doctors to be prescribing based on their clinical expertise, the best treatments that they think are appropriate for patients, and we want them to have a lot of discretion to do that. That's corporate practice of medicine from a high level. So the claims on Mochi with corporate practice of medicine is, again, that they owned the doctor group, the pharmacy, and the telehealth, and there was a financial incentive for them to push compounded prescriptions. And whether they did or didn't, they also did Zepbound prescriptions. So it's sort of like, were they diverting inappropriately? At that point, you're commenting on a doctor's discretion, right? If a doctor determines that they want to do one prescription over another. So it's super interesting. Now, what stood out to me is they were talking about this for standing. And the argument is that if doctors are not prescribing, the argument is that if corporate practice of medicine is happening, that it's actually handled usually at the state level by the medical board of California in this situation. And can Eli Lilly, a private entity, sue on behalf of consumers or try to enforce the law for the California Board of Medicine? That's an interesting question, and kind of the judge alluded to she didn't necessarily agree with that. So even if corporate practice of medicine was happening at Mochi, what does it have to do with Eli Lilly, right? For that to stand, they need to prove that they are direct competitors and that Eli Lilly had direct harms from that. So again, they talk about, and we get into, are they competing? Are they not competing? Is Eli Lilly and Mochi competing? Is a drug manufacturer competing with the telehealth plus a doctor group plus a compounding pharmacy, right? And what's interesting is I think this is how Eli Lilly messed up, okay? They brought up, on their own, they brought up Lilly Direct. And they said, well, Mochi is competing with Lilly Direct. And that's an interesting choice because I think there was some assumption, or I don't actually know the corporate structure behind Lilly Direct, where Eli Lilly, the company, and Lilly Direct are separate, was sort of the assumption and conversation. I would need to look into if that's actually the case. And literally the judge was like, oh, why didn't you mention this? This wasn't mentioned in your complaint anywhere. Why are you bringing it up now? And you could see Eli Lilly's counsel kind of feel like they made a mistake. That wasn't a good thing to bring up, Lilly Direct. And Lilly Direct is somewhat controversial, which I can get into briefly. But basically the argument is there was no actual evidence of lost sales, and are they directly competing? So this isn't my opinion on Lilly Direct. This is more context on Lilly Direct that was not included in the court case. But I think it's very interesting. There's a lot of laws that regulate pharma advertising, pharma giving kickbacks to doctors and things like that. And it's all supposed to be documented and above board, right? But what's really interesting is the state of Texas, and this case doesn't go anywhere because it's like a Ken Paxton case. The state of Texas sued Eli Lilly over Lilly Direct and basically said, because Eli Lilly spends a bunch in advertising for these medications and sends people to Lilly Direct and advertises Lilly Direct, and then if you go to Lilly Direct, they're routing people to specific telehealths or indirectly specific doctors, that's actually basically them giving a kickback to doctors. I don't think that case is going anywhere because Ken Paxton cases often don't go anywhere, but I thought that was a really interesting argument, and perhaps that has something to do with why it was not advantageous for them to bring up Lilly Direct as something that's competing with Mochi. Because then it's like, is Eli Lilly a telehealth company? Are they advertising for telehealths? I mean, I know some of the telehealths that Eli Lilly advertises on Lilly Direct, and the people who have founded those companies do a lot of advocacy work for Eli Lilly directly, indirectly. Like it's clearly like a very advantageous situation for them to be featured on Lilly Direct when Eli Lilly spends so much money on advertising. So I thought that was interesting, this minor like side rail on Lilly Direct and why it might have been a mistake that they brought it up. Okay. So then what was interesting when we started talking about competing, Eli Lilly, in somewhat the reputation harms arguments, had brought up statements basically claiming that compounded medication was both not safe and not effective. And one big change in this hearing is that they completely dropped all claims that it was not effective. And in the first hearing, the judge was just not having any of it. It was just like, you're saying like people aren't losing weight. That's not actually happening. And the judge brought up this distinction between tirzepatide lowercase or tirzepatide with a capital T, as she framed it. Meaning, if Mochi runs an ad talking about tirzepatide, are they actually talking about Eli Lilly's FDA-approved Zepbound? Are they talking about compounded tirzepatide? And that confusion between the two is kind of pivotal as to like where this case could go in certain situations. And so they brought up some ads talking about descriptions. They brought up that the FDA literally describes tirzepatide as the active ingredient in Zepbound. I'll also mention, this is mildly off topic, but the FDA has sent out a bunch of warning letters to telehealths for saying same active ingredient for compounded. So the FDA thinks it's confusing, even though that's what the FDA does. So the judge pushed on Eli Lilly to be like, hey, what exactly is misleading with these, right? What is the exactly misleading? And the question is like, are ads for tirzepatide, like there's a Mochi ad basically saying they have safe and effective tirzepatide treatments. Mochi argued in the previous hearing that saying safe and effective is actually referring to FDA-approved medication, because compounded medication is not FDA-approved, it's not gone through the same like rigorous FDA testing, and therefore you can't say compounded medication is safe or effective. So you can't make health claims like you're going to lose weight on compounded medication. That's a no-no. But when Mochi ran ads saying safe and effective tirzepatide treatment, was that inferring or implying that it was for compounded medication? Or was that actually them talking about name brand Zepbound? That was a big question that came up. It's interesting to see what happens. Now, the judge talked about, the part of the relief that Eli Lilly wanted was for Mochi to stop doing anything with compounded tirzepatide. And she thought that was highly suspicious because a lot of the framing of the case is around consumer protection and consumers getting confused and marketing and deceptive claims. So she was like, litigation is not about consumers. It's about stopping compounded tirzepatide. Super interesting. Then we got into, is this medication personalized? the difference between personalized medication, like is the actual physical medication personalized, or are we talking about personalized treatments? And let me tell you the difference because it came up in the last hearing. Personalized medicine is like literally the thing you inject in this situation, versus a personalized treatment is the entire scope of treatment. So treatment might include conversations you have with your doctor, visits with a dietitian, counseling you have on, nutrition, and, talking to your doctor about nuanced conversations about side effects, how you're feeling on the medication, and all of that together is a personalized treatment. And is that what's happening with Mochi? And is that what Mochi's claiming? Or is the claim personalized medication? One of the things we're talking about. And the judge literally pushed for like, what are the facts that it's not personalized? Because really the burden is on Eli Lilly to prove with facts. But in this situation, the judge is trying to give them the best possible inference because we're deciding if the case is dismissed at all, not going to a higher standard that we would meet if it actually went to like a jury trial or summary judgment. We went back to talking about the mass change of dosing and adding of ingredients. And, Mochi brought up, well, we had to change because of compounding pharmacies. And there's this element of like, our compounding pharmacies, if they don't offer a medication, we need to find medication elsewhere. And that might be a different compounding pharmacy that has, different options that they offer. It's interesting because, let me just say this as an aside, compounding pharmacies used to offer a lot more customization options broadly, like just stereotyping the entire industry. And they've really minimized it because it's a lot of work for them to support so many different products. So if they release a new product, they're like, okay, well, one's cherry flavor and one is lime flavor. They have to independently test those things, and that creates more of a regulatory burden on them. So compounding pharmacies decide what they're going to make or not because they have to do an entire process of testing before they can before they can have a medication that they then will dispense. So just some interesting compounding context here. Now I need to talk about Reddit. Okay? Reddit kept coming up. I think it's kind of bullshit when Eli Lilly cites Reddit because they're trying to infer really broad things about a company, and it's just a random Redditor. Like, they didn't talk to the Redditor. And in the previous hearing, the judge was like, did you talk to the Redditor? Like, she thought it was suspicious too. But there was constant interesting arguments around Reddit as a source because Mochi kept arguing you need to look at the entire Reddit thread, not just like what one Redditor says, maybe without context or like incomplete. When you broadly look at Reddit, they claimed people are not confused about if compounded medication is name brand medication or FDA approved or not. People know. And they cited a Reddit thread where they were basically talking about like, oh, this medication isn't working as well. I think I just need to find the right compounded option for me or the right compounding pharmacy to go through. And they sort of said that's like clear that they were never going to name brand. At one point, the judge was like, do we cite Reddit like it's law? Because Mochi kept referencing Reddit back. So I thought that was hilarious. I think that's a lot of the things I wanted to talk about. Let me summarize the end of it all because it went sort of on tracks and sort of not. It was over an hour. The defense ended by arguing sort of like this litigation is a long line of inferences and there aren't enough concrete facts. And the judge framed several times that she thinks she needs to infer in the plaintiff's favor in this situation. And this is if she's going to dismiss or not. And, Mochi also argued that they're not competitors, that Mochi telehealth is not a competitor with a drug manufacturer or whatever. And what's interesting is Eli Lilly came back and they really focused on like the harm is every single customer who is like misled, who, is potentially harmed or like lost sales. And it's interesting because, Eli Lilly doesn't have patient customers, and Mochi brought that up super briefly. So that was an interesting conclusion. I think what was interesting is like at the end, the judge basically said she would have an order out shortly. And if we go by her first impression when they started talking, I think this case is not going to get dismissed fully. it's possible she changed her mind listening to the argument or researching a few things that got brought up afterwards or looking at case law precedents that were brought up. But my instinct is that this isn't getting dismissed. And Mochi followed up immediately, was like, hey, are we in discovery? Which is when, they can basically ask for information and get more information, which obviously they want to prevent if it's going to motion if it's going to be dismissed. And she sort of said, like, Eli Lilly can request it, but right now we're waiting on her order. So that's it. That's the big update that I thought was going to be 10 minutes and it ended up being, 30 minutes. But I think there were just a lot of details that were interesting. Like when the judge said, since when do we take law by Reddit? So it'll be interesting to see how this goes. I was kind of expecting it to be a little bit more similar to the first time because she seemed very decided, very anti-Eli Lilly, really very much not feeling like they were standing. She was just very pleased with what they brought forth. It will be interesting to see where this goes. Let me know if you like this longer form content. I might do, 1 or 2 of these a month and deep dive into something because I have so much knowledge on this stuff in my head that I don't get time to share and I have to edit down to a short video when I do short form content. But thank you so much. Please give me a follow. And if you are in the market or wanting to compare options for GLP-1s, compound or name brand, I don't care. Check out my tool.